Good afternoon. Welcome to the College of Law. I'm Jason Craig, the director of the program in criminal law and policy. And I'm thrilled that you're joining us today. For those of you who are present, I'm thrilled for those of you who are joining us virtually or will watch this at a different time that you're joining us today. I'm pleased to introduce what will be a series of events on prosecutorial decision-making, prosecutorial ethics in real life. These events are the result of the work and the vision of Paul Charlton, who's here with us today. Paul Charlton is a professor of practice at the College of Law and a current partner at the international law firm Dentons. Professor Charlton teaches here at the College of Law prosecutorial ethics and decision-making. If you're not in the class this semester, I encourage you to take it the next time it's offered, regardless of whether your interest might be prosecution or defense or some other part of the criminal justice system. Prosecutors have immense power and discretion in the system, and Professor Charlton's experience makes the class, I think, essential for those of you who want to work in the system going forward. So I encourage you to take it. There simply isn't a better person to teach a class like that or to lead a discussion series on prosecutorial ethics in real life than Professor Charlton. Now, I'm biased because he's a double wildcat, having graduated both from the undergrad here at the university and at the College of Law. But more importantly, Paul's career as a prosecutor was lengthy, and it required him to see the criminal justice system from a variety of angles in dealing with tough questions, and some of the questions I'm sure that we'll explore today as a part of this series. He started his career, Professor Charlton, as an assistant attorney general. He then moved to the U.S. Attorney's Office, where he served as an AUSA from 1991 to 2001. And in 2001, he became the U.S. Attorney for the District of Arizona, a role in which he served for approximately 6 years. As a prosecutor, and in particular in his role as the U.S. Attorney for the District of Arizona, Professor Charlton faced many tough ethical decisions in his work. These included, for example, when is it appropriate, or when is it maybe not appropriate to seek the death penalty, even though the case might be eligible as a capital case. Prosecutors have discretion in how they want to pursue a case. In addition, how do you handle a situation as a prosecutor where you're investigating or potentially building a prosecution for a public figure or a politician? And Professor Charlton, as a U.S. attorney, was an early voice, particularly among prosecutors and law enforcement, was an early voice calling for law enforcement to record interrogations and interviews that they do with defendants and witnesses. Now, in each of these instances and in others, Professor Charlton was called on to make tough decisions, use his ethical judgment to figure out what was the best way forward. Given this, I'm excited that he's joined us here at the college as a professor of practice. And I'm grateful that he's leading this series of discussions on prosecutorial ethics in real life. So please welcome Paul Charlton, who will introduce our guest today and the rest of the program. Paul.
Well, thank you, Jason, for that very kind introduction. Thank you for your assistance in bringing forward these speakers, and thank you to the Dean as well for your assistance, Nancy Stanley, as well for all of your assistance. This has been a wonderful experience for me to bring in outstanding speakers like our first speaker in this series of speakers. Prosecutorial ethics and good decision-making are the cornerstone of our justice system. And the first speaker we have in this series is a terrific example, in my mind, of a prosecutor who has faced extraordinarily difficult situations and had to make equally difficult decisions in his career. Justin Oshana, who's here with us today, is, as you probably have seen already, the principal prosecutor in the prosecution of Bowe Bergdahl, who left his post in Afghanistan. He was also one of the defense attorneys for then Major Nidal Hasan, who was involved in the mass killing of a number of individuals in an army base. We're going to hear a little bit about both of those cases from Jeff in just a moment, but let me give you some background about Jeff. He is a George Washington undergraduate. He is twice diplomaed at Temple, first year JD, and I believe you have your master's degree from there as well. Have I got that right?
You do, in trial advocacy.
In trial advocacy, well, that's perfect. And he is also, of course, a veteran, twice deployed to Afghanistan. Served in the JAG, had these high-profile cases that we're going to hear about. Currently serves in the reserve as well. Is that right?
That's right.
What's your rank currently in the reserve?
I'm a major.
Major Oshana. We should probably make sure we get that correct. and then is also an assistant U.S. attorney. I admire people who seek out public service. I think it is a noble profession. And you, Justin, have sought that profession in two ways. First, you wear the country's uniform even to this day, and I admire that as well. I want to hear a little bit about, if you would, how it is you were drawn to public service, how it is you were drawn to serve the public in uniform, and then how it is you were drawn to continue to serve the public as an assistant U.S. attorney where you currently serve the public in Philadelphia.
Well, absolutely. First of all, thank you, Paul, for inviting me, and thank you to all of you for being here. I appreciate it. I'll actually kick off with my first example of an ethical obligation, and that is that I must tell you that everything that I say is in my personal capacity and does not represent the views of the Department of Justice or the Department of Defense, which my ethics counselors made sure to remind me that I have to kick off with. In terms of, I agree with you, first of all, that public service is a noble cause and it is critically important. How I was drawn to it, I guess, goes back to my childhood. So I'm from Philadelphia. My grandfather, who married my grandmother after my father was, I think, 3 or 4 years old, and then adopted my father. He had served in World War II, but he's Japanese American. And so he joined the army from an internment camp and spent the rest of his career in government. And that was very inspiring to me, that someone who had been wronged by the country, nevertheless devoted his life to serving. My first job out of law school was as a clerk on the district court in the Eastern District of Pennsylvania. And I clerked for a man named Clifford Scott Green. Unfortunately, he actually passed away while I was clerking for him. But he had been appointed by Richard Nixon, so he'd been on the bench for quite some time. He lived a very good life. Judge Green was African American, also served during World War II. And he told a story about how he, when he was going down to Fort Lee, which is where he started in the Army, and ultimately actually was where I started in the Army. That was where I reported in for the first time. He was on a train and he was going past these kind of newly constructed barracks, and he thought, maybe this isn't going to be so bad. The Army could be good. But of course, those were the barracks for white soldiers. And then he ended up continuing past that into the tents that were reserved for African Americans. And in spite of that, he spent his career also largely in public service. He spent 30 years on the federal bench and was on the state court bench before that. So both of them were really inspirational and important in my decision to be in the Army in particular, but also just to reinforce my belief that public service is important. It is critical towards our country's success, and that if citizens aren't willing to basically put some skin in the game and participate in our process beyond just the sort of basics of voting and jury service, that the country basically just can't function. And so on a sort of, I guess, personal level, I also find the work to just be very satisfying. I was telling Paul before we got started, I work in Philadelphia. The U.S. Attorney's Office there is right across the street from the Liberty Bell and right across the street from Independence Hall. And then on the other corner is a building that's about 100 years old that just got renovated to include apartments, and that's where I live. So my life is kind of combined into a weird 1-by-1 block radius, but it also means that I wake up every morning and I walk my dog behind Independence Hall. And it's just very inspiring to see that every day. And it just really helps to reinforce why I do what I do and why I enjoy it so much.
I think, Justin, many of us here would be familiar with the criminal practice that we might see in state, local, or federal court. But I suspect many more of us, me included, are not familiar with the practice under the Uniform Code of Military Justice. how it is that transpires. So perhaps you could just give us a very quick primer on what, if any, differences there are in trial practice and in criminal law as it's practiced within the military. And then maybe your beginning, and if we could, because we have such a limited amount of time, how it is you became involved in the prosecution of Bowe Bergdahl.
Well, the system is actually very similar to the federal system. It's largely modeled on the same statutes that you find under Title 18. The military rules of evidence are almost a perfect analog to the federal rules of evidence. There are differences. The two most substantial differences, well, one exists right now but is going away, and that is the involvement of commanders in making the decisions about whether or not a case goes forward. And that has been an authority that they have had for a very long time. So we're talking about non-lawyers getting to make some pretty critical decisions. Now it's changed actually even from when I started. So when I first was my first job was as a prosecutor in the Army, and that was in 2008. And at that point, what was called a convening authority, which is a general officer who's in command of typically a division or higher level unit, would get to make the decision about whether or not to send the case to court-martial, and then had to approve whatever sentence was given, and could set aside the conviction itself or the sentence or any portion of it. And they were doing that with the advice of lawyers, but they were not lawyers. And that led to a tremendous amount of criticism and congressional oversight. And Senator Gillibrand of New York in particular has been kind of leading the charge on changing that. And so commanders were largely stripped of their authority to set aside convictions and sentences in the, I believe it was the Military Justice Act of 2016. And the NDAA that has just passed includes a provision that's going to remove them entirely. And so you'll see something that is much more similar to a federal system where there will be an appointed judge advocate, potentially a civilian lawyer, but a lawyer making the decision about whether or not a case goes forward.
The NDAA is the
National Defense Authorization Act. It's the mechanism by which the military is funded, and it gets passed on a yearly basis, but also frequently includes other changes to the system. It's not simply a funding.
So with that understanding, that change, I do want to touch upon one fact that's going to become relevant here in a moment as we discuss the Bowe Bergdahl prosecution. There is a commander-in-chief in the military. That's the President of the United States, who is very literally your most senior officer. Is that correct? As a layperson, is that an accurate understanding of the way that works?
Sure, I guess we wouldn't technically call him an officer, but he is the ultimate command authority.
Share with us, if you would, how it is you became involved in the Bowe Bergdahl process.
Well, it was 2015, so Bergdahl was released in summer of 2014, actually while I was deployed for the second time. And in a sort of strange twist, I remember when he was taken, because I was also in Afghanistan 5 years earlier, in 2009. I remember both events very clearly because the rescue efforts for him were just overwhelming. And everyone in that part of Afghanistan was impacted in some way, whether it was just that we spent a lot more time in bunkers because we were getting rocketed a lot more because all the assets were down looking for him, or the people who actually went on the ground and went in the air and tried to find him. And then I remember when he came back, I had a conversation with a friend of mine who was also in Afghanistan, who was actually also one of the defense attorneys on the Hasan case. And it was the day that he came through Bagram, which is where we were. And then Lieutenant Colonel Martin said to me something along the lines of, we were going back and forth on is he going to be court-martialed? We both agreed, yeah, he's going to be. And Colonel Martin said, somebody's going to have to prosecute that guy. I said, yeah, I feel really bad for whoever that is. So I finished that deployment, and I was working at the Philadelphia District Attorney's Office when I got back. And he was charged in March of 2015 with 2 counts, what's called misbehavior before the enemy, which is a fairly rare charge, and with desertion, which is more commonly understood and prosecuted more frequently. The place that he was prosecuted at is called the United States Army Forces Command, or FORSCOM. It's a 4-star command. There's only 3 of them in the Army. And as I said, the way courts martial work is that a convening authority pushes a case forward. Well, FORSCOM, though technically a convening authority, had never done a court martial. Court martials were handled at the 3- and 2-star level generally. It was sent there for a variety of reasons, some of which maybe made sense, some of which didn't. But the bottom line is FORSCOM did not have a military justice shop. There were no prosecutors assigned to that command. So they had to create the prosecution team for Bergdahl in an ad hoc basis. And the team that they had at the time of charging was kind of drawn from a number of different places, but it was relatively small. And they sent out what are called credential search requests, which is how you start the discovery process in a case that you think might have either some classified information or high volume information in a variety of places. And they got back their first batch of production from CENTCOM, which is the command that handles all operations in the Middle East. And it was 1.3 million pages. And it was almost all classified. And I think at that point, there was a realization, like, I won't use profanity, but I'm sure they did at the time, we got a problem on our hands here, and we are going to need some additional assistance. So they were looking for reservists who had experience with dealing with high volume, high profile, intensive classified litigation and discovery. And I fit that bill. So in September of that year, I went down with the idea that I was going to be helping them to get through the discovery process, which they estimated at the time would take like 6 to 9 months. I thought, okay, that's not that big a deal. Of course, I ended up being there for 3 years, so it didn't quite work out the way I had expected. But that's how I initially became involved, was in an effort to help them get through the mountain of discovery that we had.
What happened next? A great prosecutor question.
Yes, yeah, it's a great lawyer question generally. It's the easiest way to, you don't know what other question to ask, just ask what happened next. Well, a couple of things were going on. I mean, the people who were leading the team at the time really didn't have a good appreciation for exactly how difficult this was going to be. In their experience, it was sort of like, yeah, I've prosecuted desertion cases, start to finish, they're 9 months. And so they were operating under a timeline that was not necessarily realistic. And so part of what I was trying to do initially was saying, we need to really educate our senior leaders that anybody who thinks this case is going to complete itself in 2016 is out of their mind. But then sort of 2 events happened that butted heads and resulted in me being in charge. We hired, as the prosecutor, and this actually happened before I got there, but the prosecution hired a guy, retired FBI agent, to do some work for us in helping us with organizing and presenting material. The problem is that guy had been interviewed as a potential investigator by the defense. Now the interview only took maybe 10 minutes, and they told him what they wanted, and he said, look, I don't think I'm your guy, but here's who I recommend, and that's actually the guy they ultimately hired. But when we hired him, we did not tell the defense that we had done so. Separate from that, when you're dealing with classified litigation, each side in the military gets what's called a security manager. And that person is responsible for ensuring that you don't have disclosures of classified information, and they do other tasks like helping with security clearance and things like that. So each side had one and the judge had one, and they were all from the same office. They were all civilians working in FORSCOM. The boss was for the judge, and then these 2 other GS employees were for the prosecution and the defense. Now, the defense guy was appointed as a member of the defense team with a duty of confidentiality to the defense and the defendant. What ended up happening is that our guy got sick. He had not a stroke, but a stroke-like event. He was basically incapacitated for some period of time. My predecessor went to him and said, to the defense security manager, and said, you're going to now wear 2 hats. You're going to be doing work for us and continuing to do work for the defense, but you're not going to tell either side what you're doing for the other one. And my predecessor did not either tell the defense or seek their permission in order to do this. Okay, how does this all come to a head? Well, that security manager starts processing the security clearance for the investigator that we had hired. And he accidentally sends an email to the senior military defense counsel saying, here's the status update on this guy's security clearance. He responds back naturally saying, what are you talking about? We didn't hire that guy. To which the security manager responds, I can't answer any more of your questions as instructed by the prosecutor. So that was a moment that sort of blew up in everybody's face, and the decision was made to remove my predecessor, and I was asked to at that point stay for the duration, because I'd only agreed at that point to stay for potentially like 9 months, and leave the team. So it's a great example of one of those situations as a prosecutor where you can look for a way of saying, does the rule require me to do this thing? Right? And so did the rule technically require notification that we had hired this guy in the internal capacity, not as a testifying expert, not anything like that? You could probably get to a way where the answer to that is no. I think the answer probably was yes, because the defense, having talked to that person, needed to have the ability to object. And you could maybe rationalize a way of saying it's okay to have somebody dual-hatted. But again, would you do that in such a way that you're not open about it? And I think there's lots of examples, as I'm sure you are also aware, of prosecutors who have done that in a number of different settings, whether it's, do I disclose this piece of evidence? Do I tell them that we've done this thing? And instead of asking the question, what should I do? Or am I prohibited from doing this? Prosecutors sometimes ask the question, am I required to do it? And then they try and come up with a novel reason why the answer is what they want it to be. And that's how a lot of prosecutors get in a lot of trouble.
So in the ethical rules here in Arizona, and I think it's in the model rules as well, the comments for civilian prosecutors, as you know, indicate that prosecutors have to act as a minister of justice. Is that part of what it is you're talking about here?
Absolutely.
Obligation is broader than what might otherwise be required for other lawyers?
Yeah, I think if you ask any prosecutor, what is your fundamental responsibility? Their answer will be to seek justice. That is drilled into, or at least said to every prosecutor whenever they start a job, whether it's at the local DA's office or wherever. The problem is twofold. It's what does justice mean? And how over time, some people move away from what I think it actually means into a way of trying to just get convictions or decide in a particular case that it's more important that this person go to jail. So I think justice means accepting that sometimes the result is not going to be what you want. But sometimes justice is an acquittal. Sometimes it's evidence being suppressed because someone's constitutional rights were violated. And even if that means that the person who is absolutely guilty, has committed the crime, is not going to be able to be held accountable, that's still justice. Whereas some people end up believing that what their responsibility is to seek justice for the victim, which on some level is part of our responsibility, but it's underneath our overall responsibility to seek justice for the system. And I think over time, some people end up straying away from that and not necessarily doing something intentionally unethical, but taking their eye off the ball in terms of what our responsibility really is I think how people end up making those kinds of mistakes.
I suspect the Bergdahl prosecution alone would be worthy of a semester's long class, and I hope you consider that at some point in time. But given the time considerations, I wonder, Justin, if you could talk about another issue that you faced, decision-making point, that eventually resulted in your writing an op-ed in the Washington Post, which the folks here have had a chance to see a hard copy of.
Sure.
But perhaps the events that led up to that 2020 decision of yours to write that op-ed decision would be of interest to me.
Yeah, so you're right, absolutely, that there are innumerable examples of things we could talk about with regard to Bergdahl. But the case became very politicized very quickly. There was obviously a lot of controversy over President Obama's decision to trade these 5 former Taliban members in exchange for Bergdahl, who were actually, at least 4 of them are now back in Taliban leadership. And the administration did not handle, frankly, the rollout of that particularly well. They held this Rose Garden ceremony with his parents. Susan Rice, who was the national security advisor, went on TV and said that Bergdahl had served with honor and distinction. And it just fueled the fire of right-wing Republican Fox News criticizing the decision. And you started to see a lot of misinformation being spread around. And one of the things that I was concerned about throughout the course of my time on Bergdahl was that I was able to watch how the case was being presented to the public in the media, knowing that a lot of it was wrong, because I was obviously on the inside, right? So one of the great examples is that Fox News, whenever they would cover it, would put up this graphic of 5 or 6 soldiers who they said were killed looking for Bergdahl. And the truth is much more nuanced than that, as it often is. But really, all of those soldiers who were killed between August and I think October. The reality is, by that point, we knew that Bergdahl was already in that. So you can't tie a line directly from him to those deaths. And that's why we didn't even try and present it in the court martial. Now, you can tie a line directly from him to some very serious injuries that occurred in the immediate week or two search period. But I was seeing that happen, and it was bothering me, because I had to ask myself, if the only reason I know that what I'm watching on the news or reading in the press isn't true, is because I'm involved in the case, how can I trust what I'm seeing in stories that are covering things I'm not involved in? And then the other thing that happened, of course, is that then candidate Trump turned it into a campaign rally issue. And he said in kind of increasingly gruesome and crazy ways what he thought should happen to Bergdahl, to include pantomiming shooting him and saying 30 years ago he'd been executed, to polling the audience on whether or not we should throw him out of an airplane and should he have a parachute or not. He did this like 80 times. And at the time, the defense would complain about it in filings, and I would write back snarky responses that said, there's no legal theory under which a candidate for president can derail a court martial, largely because I did not think candidly that Donald Trump was going to win. And then he did. And I thought, okay, this is potentially a problem for us. So we started very early interfacing with first the transition and then the administration to say, look, now that he's president, he simply can't talk about this, because there's a concept called unlawful command influence. The president is absolutely capable of doing it. And now that he's commander-in-chief, he just can't talk about it. And we were successful with that. I remember vividly sitting and watching the inauguration and having my BlackBerry, because that's what they had from the military at the time, buzz because they had somebody waiting to press send on the motion to dismiss, like the second his hand came off of the Bible. And so we litigated that. We were successful. He remained, the president didn't say anything about it until the day of the guilty plea in October of that year. So we're talking October of 17. And he was asked a question in an impromptu press conference about the case. He said something like, well, you know, I think they're setting up this thing down there and they're doing sentencing, so I can't talk about it. So I'm not going to comment on that. And he said, but I think everybody has heard my comments in the past. So that resulted in a renewed motion to dismiss. We ended up having to litigate that in a very uncomfortable hour-long hearing where I was grilled by the judge as to what does the word "but" mean, and very nearly, I think, caused the case to be dismissed at that point. The judge then said, you know, not to dismiss the case, but I'm going to consider it as mitigation, which I think is largely the reason that Bergdahl did not spend any time in jail. And that was the subject of the appeals. And frankly, the case almost was overturned twice. At the intermediate court, it was a 2-to-1 vote, and at the Court of Appeals for the Armed Forces, it was a 3-to-2 vote. And it was almost entirely about the question of whether or not what the president had done constituted unlawful command influence. So I felt an obligation to say something. I didn't want to do anything while the case was still pending appeal, because I didn't want to prejudice the conviction in any way. So once the Court of Appeals for the Armed Forces upheld the conviction, which is effectively the last level you can petition to the Supreme Court, they have not. I decided that the things I had been thinking about and the concerns that I had about how we digest information in this age and how can you trust what you hear, and is it appropriate for political figures to inject themselves into the criminal justice proceeding? It was time for me to say something about that. And so I wrote the op-ed.
It was an eloquent piece, is an eloquent piece, and I encourage everybody to read it. It's a very thoughtful piece of writing, and I hope influential for others in leadership to read. But a couple of questions. Can you, again, for the layperson, explain what unlawful command influence would mean in the military, and why it is when the commander-in-chief weighs in on whether or not he should be executed, or how it is that could create this issue, unlawful command?
So it's based off of the UCMJ. There's an article that prohibits a commander from attempting to influence the decision-making, the independent decision-making of their subordinates in the criminal justice, and the military justice system. And so the most egregious example would be if the commander ordered either, because remember, the jurors in the military are also all military officers or enlisted in certain circumstances, ordered them or pressured them in some way to give a certain result or a certain sentence. And it applies to the members of the court, the jurors, to the judges, to everybody in the system, to the convening authorities. And it's an important protection, right? Because you have legal obligations as a soldier to do what your senior officers tell you to. And so that's the principle, is don't try and use your authority to influence the outcome of a court martial.
So we talked a little bit about the obligation of a prosecutor to act as a minister of justice. Did that play a role when you reached out to your leadership to have conversations with the executive, the president's office, so as to tamper, if not completely shut down, his dialogue, his public dialogue about this case?
Absolutely. I mean, I think it was twofold. One, from a very practical standpoint, I knew that if he came out and said those same things again, it was going to sink the entire prosecution. But yeah, look, I believed and continue to believe that part of my obligation as the trial counsel in that case was to do what I can to ensure that the accused had a fair trial. And I did not think and do not think it was fair for anyone to publicly condemn a defendant in that way. Obviously, most of all for the President of the United States. So
Let me move from sort of the realm of prosecutorial ethics to just the decision-making process here. Because when you wrote this op-ed piece for the Washington Post, you were an assistant U.S. attorney here.
that's right.
In the District of Arizona. And the U.S. attorney was a U.S. attorney appointed by President Trump.
Yep.
And the Attorney General of the United States was Bill Barr, if I've got my chronology correct.
You do.
And his record is pretty clear on his allegiance to the president. Did you have any concern penning an article while you were a reservist in the Army and an assistant U.S. attorney that was going to openly criticize your civilian boss, the president, and your commander-in-chief, the president?
Well, I'll answer that in two ways. I consulted with the ethics advisors to make sure that I was allowed to do this. I was pretty confident that the answer to that was yes. But yes, I was absolutely aware of the fact that there was a possibility that I was going to get fired. Not that it would be a righteous firing, but it would not have surprised me at all. And I sort of thought that I had a small window where if the president saw it and got angry and called the attorney general or maybe just tweet fired me, that there was a possibility I wasn't going to have a job. So it wasn't a consideration in terms of whether to do it. It was more of a consideration of, okay, having made the decision to do this, let's make sure that I'm prepared for the potential fallout that comes from that. But ultimately, I think that there are not necessarily all that many occasions in the lives of ordinary people where you have an opportunity to say something on a platform where other people are going to listen to it and pay attention to it. And if you choose not to speak in those moments, then I believe that you're complicit in whatever the wrong is that you believe has been committed. And so I thought my obligation as an attorney, as a military officer, and just as a citizen, was more important than whatever the potential fallout would be from making that choice.
What was the fallout after that article was published?
Well, the feelings were pretty mixed, although mostly positive. I received a lot of good job type of messages. I received some death threats and some pretty angry comments about how I was, I should be prosecuted myself. I was a traitorous type of language. But ultimately, as happens with I think a lot of things in the world these days, we moved on to whatever the next crisis was going to be. And so I didn't experience any long-term consequences or anything like that.
With the passage of time, have you thought any more about whether or not you would do it again? So are you comfortable with that decision?
Well, I never questioned whether I would do it, so it wasn't really an issue of whether I would do it again. I'll tell you one fun anecdote in terms of the response. I was flying back, so I was actually on the East Coast when the decision came out. I wrote the op-ed. I was staying at my best friend's house in Annapolis, and I wrote the op-ed on my phone, in the notes section of my phone. For whatever reason, I wrote a lot of things that way. So I still have the first version saved in my notes section. And I contacted people I knew at the Washington Post, and it got published. When I flew back to Arizona, I landed, and I got a message from my office that said that John Kirby, who was a CNN personality at the time, is now the spokesperson for the Pentagon, and he'd been a Navy admiral, that he was trying to find me. And they had a phone number, and so I called back and picked up the phone, and he said, John Kirby here. I told him who I was, and he said, Chuck Hagel wants to talk to you. Chuck Hagel was Secretary of Defense under President Obama, was senator for many years before that. I used to work for him, and so when he wants to find someone, he'll sometimes reach out to me and say, find this person, let them know I want to talk to them. So I said, sure, of course I'll talk to Secretary Hagel. And like a week later, I get a phone call from a blocked number, and I pick it up, and it says, Justin, Chuck Hagel. And we had a very nice conversation. He was basically saying, I appreciate what you wrote. And then he actually wrote a letter to the editor of the Post about 3 days after that, which was very kind of him to do, praising the decision to write it. So
that leads me to another part of this that I'd like you to talk about, and the high-profile nature of some of the people that you ran into. I understand you were the defendant in a lawsuit by a high-profile individual. What if you could share that story?
I was. So some of you may be familiar with the podcast Serial. Season 2 was about Bergdahl. And the basis that they had for producing that season was a series of interviews that Bergdahl had done with Mark Bowl, who's a film producer who won a couple of Academy Awards for Hurt Locker and Look 0 by 30. And he had all these things that Bergdahl had said that they were broadcasting. We were hearing it on a weekly basis, happening kind of as we were going through the prosecution. And sometimes it would just be a snippet of something he said. Sometimes the host, Sarah Koenig, would paraphrase what Bergdahl had said. But it was things we wanted to use. And obviously, just in the broadcast format, it wasn't going to be something that we could get from an evidentiary standpoint admitted. So we decided that we wanted to hear the rest of it. So I engaged in months of negotiations with his lawyers about a potential subpoena to get that information. And there's a whole discussion that we can have on qualified reporter's privilege and whether or not we have access to that. But we had a case that was on point. We were pretty confident we could get it. And I was at a hotel in DC, and I get a phone call from his lawyers, and we've had a lot of back and forth at this point. We had an amicable relationship, and they said, look, we're filing a lawsuit. We're going to seek a restraining order, and we're going to name you as one of the defendants. And so I remember sitting in the hotel room, and I said, I'm not Irish, so please don't put an apostrophe in my name in the lawsuit, which we all laugh about. And then my co-defendants, I don't recommend being sued if you can avoid it, but my co-defendants were the President, the Secretary of Defense, the Secretary of the Army, and the Force Council. And then right at the bottom, Major Nidal Hasan. So it's a good list of co-defendants. Now, you can imagine that when they sued us in the Central District of California, so in LA, and when the judge decides to do a settlement conference with that list of defendants, you can imagine that the only one that the government is actually going to send is the guy at the bottom of the list. So I made my way out to LA. I was represented by Maine Justice from the Civil Division. There was AUSA from the local U.S. Attorney's Office, and then there was a military attorney from our litigation division. And the way settlement conferences work generally is you sit down with the judge and you explain your side for 20 or 30 minutes, and then the judge sits down with the other side and gives their side, and you kind of try and figure out how you can broker an agreement. So we did that. We did our 20 minutes with the magistrate judge out there. Then we went up to the cafeteria, thinking we were going to wait for 20 or 30 minutes. We were up there for an hour and a half. She calls us back in, and she says, he's never going to give you anything. And he's told me that, obviously, the last hour and a half. He knows what the maximum penalties are. He thinks it's a First Amendment issue. He's just never going to give you anything. But then she points at me, and she says, but he wants to talk to you. Okay, that's weird, but I'm a party, so it's not like there's an issue there. So Mark Bowe and I go into this jury deliberation room by ourselves. And I remember there was this bowl of mints. I'm in my dressing uniform. And he spends like 10 minutes telling me how he's never going to give me anything. He kept saying, man to man, you're not getting it. Here's why. And I'm just sort of sitting there listening to him. I remember just eating mints and kind of nodding at him. And he finishes his spiel. And then I say, okay, what about this material? He said, I guess I could give you that. You have a starting point. And then 45 minutes later, we walked out, much to everybody else's surprise, we're like, hey, we worked it out. And so we got some of the material that we needed. And it was a bizarre experience, one that I hope to not ever repeat, but I still am occasionally in contact with Mr. Bowe. He was actually very helpful in terms of giving me some advice on the Washington Post op-ed. So, yeah.
So we have about 10 minutes before we should probably take some questions from the audience. And it's not a sufficient amount of time, I'm certain. We are moving away from the issue of prosecutorial ethics and decision making, but I do want to hear about your role with Hasan and your work there, and your view, because it is an interesting career in which you had this extraordinarily high-profile prosecution and then participation in an extraordinarily high-profile defense.
Yeah, well, I'll tell you a couple of things. So I've been a defense attorney both on the civilian side and in the military, and not just on the Hasan case, but a defense attorney in Korea. And I bounced back and forth. You get to do that in the military. I started off as a prosecutor, and I was a defense attorney for a while, and then back to be a prosecutor. And I've been a public defender in Philadelphia and a district attorney in Philadelphia. And I really believe that that was a valuable thing for me and helps guide me when I'm making decisions as a prosecutor, both in terms of what my ethical responsibilities are, but also in terms of how to best use prosecutorial discretion. Because I think it's very easy, particularly as a young prosecutor, to get wrapped up in your case and not necessarily focus on questions like, how should I judge this defendant? Can I understand why they're not accepting what I think is a very rational plea agreement? And until you sit down with that person and really realize that they're thinking about spending 5 years behind bars, for them that's a long time. And having empathy for a defendant is something that I probably lacked a little bit at the beginning of my career, but as I was able to interact with defendants as their attorney, I think I developed a better ability to do. The Hasan case was interesting. It was a very straightforward case in terms of the actual guilt or innocence. It's obvious that he had done it. He was shot at the scene, was paralyzed. He killed 13 people, including a pregnant woman. He shot 32 other people. He was specifically targeting soldiers. He would not shoot civilians unless they tried to stop him. And so it was a horrific case. And when I got to Fort Hood for the first time, my boss said to me, look, Justin, if right now we have a 1% chance of giving him a life sentence, our job is to make that a 2% chance. But it was, so my role was as one of the team of three, just doing pretrial litigation. And it was really me and Lieutenant Colonel Chris Poppy, who's a brilliant defense attorney. We were focused mostly on doing the litigation piece, and then Colonel Martin, who was the guy who ultimately was in Baghdad with him when Bergdahl came back, he was focused on the mitigation aspect. Mitigation in capital cases is a huge undertaking. And it's interesting, capital litigation is hard as a defense attorney, obviously, because you have to try and divorce the emotions of what happened. And particularly in a case like that, where as a soldier, it was deeply, deeply offensive to me that what he had done and the fact that he had targeted people because they were soldiers. But from your responsibilities to your client, I spent a lot of time, with Oshana, who would bring to us on a weekly basis. Some of it was very difficult. I remember the first time he made a stupid little joke. I'd gone to get him to sign something that we forgot to have him sign. He said, something like, "Oh, long time no see." And I laughed. As I was walking out, I was thinking, "You're laughing with a mass murderer. This is really, really weird." But our obligation was to, as I said, try and move the needle to some degree, and we focused on doing that. So, but working on that case, as I said, I think just going back and forth generally, working on that case as a defense attorney and then being asked to work on the Bergdahl case provided a foundation that was very helpful when I came time to be on the other side.
I like the word empathy. I like the idea that a prosecutor should have empathy. Many people might hear that and think that that's a handicap, that in some way would inhibit your ability to seek justice. Can you explain why it is that's a quality worth having?
Sure. Well, one of the things that I've said as a defense attorney or learned as a defense attorney, and I think now trying to apply as prosecutor, is that no one should be judged on the worst thing they've ever done. You have to be held accountable for it. But when you're taking into account as a prosecutor, what is the best disposition for this case? If you're not also taking into account things like, what is this defendant's history and background? Is there something that led them to this? Do they have no criminal history? And this is just really aberrant behavior. Every case has to be judged on its own merits, and unless you're willing to also include the other side in that consideration, then I think you are never going to be able to fully exercise prosecutorial discretion appropriately. Because not every case needs to go to trial, not every case needs to be charged. And if you look throughout the country, there are now all these diversion programs that have extraordinarily low recidivism rates, veterans courts, and drug treatment courts, and DUI courts, and all sorts of ways that you can still achieve justice for in the all-encompassing way. But if you're solely focused on the harm that was caused by the individual and you're not spending any time thinking about what led them to that position and their background, and I just don't think you can do the job as effectively as you should. And I think it is one of the things that leads people to make those ethical lapses and to decide that it is okay to maybe come up with that novel argument that says, I don't have to turn this over. Because they're laser focused on, I am going to achieve some justice for the community and the victim, and this person has done a terrible thing.
You're an assistant U.S. attorney in Philadelphia now.
Okay.
You enjoy that work?
Very much so. It's not easy. Philadelphia has experienced an epidemic of gun violence, and we are on track to have the most homicides in our city's recorded history, which is personally, obviously, very troubling, both as a prosecutor and as a native Philadelphian. And I work in the violent crime section, and we spend a lot of time. When I was in the violent crime section in Arizona, where I did mostly gun trafficking cases, with the occasional like bank robbery. And in Philadelphia right now, we're seeing a lot of federal prosecutions for really heinous crimes. I've got a kidnapping case where the cartel was the kidnapping of a 17-year-old. And the FBI heroically rescued this kid and ended up killing one of the kidnappers. I've got a case where a guy shot a pharmacist while trying to steal Oxycontin. I'm working on a case that's a string of 8 or 9 bank robberies that were all gunpoint, including one of the defendants who was charged in this, but he's 15. They're running around with guns. But I do think that when you go back to the first thing that we talked about, when you're in a position where you're seeing something like that happening, where there's a rise in crime, it's very important to have people who are dedicated to the mission and are able to try and address those issues and solve some of those problems. You can't do it by yourselves. It's something that has to be a multifaceted approach. But yeah, I'm very pleased to be part of trying to combat that problem and enjoy the work and think it's important.
Justin, if it's all right with you, I think this is probably a good time to stop and see if there are any questions from the audience. Yes, Professor Silver.
Yeah, what we're seeing around the country now are district attorneys, county attorneys, etc., labeling themselves as progressive prosecutors.
Philadelphia
being maybe one of the first.
Yes.
And I think they see their role as much beyond just prosecuting cases. Fiction, integrity units, you mentioned diversion, and a lot of other programs. What's your take on that? Is that, I mean, is the only way the criminal justice system is going to be reformed more prosecutors see their role much beyond just prosecuting cases.
Okay, let me just repeat the question about, and I'll summarize it, Professor Stevens, so make sure I got it, because I think people can't hear. But it was that there are a number of prosecutors, including one in Philadelphia, who have identified as a progressive prosecutor with some interesting ideas about how it is the criminal justice system should be reformed, and what is your view on that?
Well, I'll start by telling you I have some strong personal feelings about the district attorney in Philadelphia, because he fired a lot of my friends and did so in a way that I think demonstrated a tremendous lack of integrity and leadership. That being said, I think there are some policies that are instituted by prosecutors in these areas. Houston has one, there's a number of them that have been elected, that I think are overdue and are good for the system. You know, attempts to end cash bail, the conviction integrity units that you talked about. I think the problem becomes that some of these offices focus exclusively on that to the exclusion of appropriately prosecuting those cases where we really do need to have some accountability in terms of a criminal prosecution that involves potential incarceration, potentially very long incarceration. And anecdotally, we've had a number of cases where some of the defendants who were out there committing crimes that I'm now prosecuting were in the state system and were released for a variety of reasons that probably shouldn't have. So the second part of your question was, do I think that's the only way that necessary criminal justice reform is going to happen? I don't know. I think that the degree to which the country has become polarized and the political climate right now really does make it difficult to come together and have rational conversations about things that we should change and that are perhaps overdue for change. So do I trust that Congress is going to step in and make some of these changes? And obviously that's not a good example, because you're not going to see too many U.S. attorneys that are appointed on this vein. But yeah, I think that there is a lot that an individual district attorney can do, and some of the policies are great. I just think it's, for a lot of those offices, it's kind of an all or nothing thing, and that's unfortunate.
Any other questions?
Yes, Dean, Professor.
It's just a follow-up on Andy's question. What if one of the things that the prosecutor did was say, we're going to follow the JAB model, and we're going to preference someone who's both served as a defense attorney and a prosecutor when they're interviewing or thinking about hiring ADAs or assistant county attorneys here. Krasner's background was exclusively as a defense attorney, and some of the progressive prosecutors have also been defense attorneys, some not. But what if that was the one thing that they took from as a kind of minimum requirement? When I'm interviewing and hiring new prosecutors, I'm going to search out people who have served as a defense attorney in part of their career.
Do you want to summarize that question first?
Yeah, so the question was, would it make sense for some of these offices to prioritize folks who've also been defense attorneys in their hiring practices? And you're right that not only was Mr. Krasner a career defense attorney, but he has hired quite a number of people who were at the public defender's office, a number of friends who were working there. I think that's potentially something that could be useful. Now, look, what you'll find, I think, when you look at a typical DA's office and a typical public defender's office, this is certainly true in Philadelphia. So I'm guessing to some degree, but I guess that it's probably true in other places, is you have a lot of lawyers who are of the belief that I can only do one, right? We call them true believers in government acts in the military. And the true believers were, I'm never going to be a prosecutor, and the prosecutors fall under the, how can you go to be a defense attorney? How can you know your client's guilty? Both of those extremes, and they're not really even that extreme necessarily, or I should say, I think a lot of people fall within those two. I think they're both way off, because I think that they are forgetting that both jobs are essential to the system working, and that people operating in both those jobs who are ethical and who are exercising their responsibilities and their discretion appropriately are the only way that the system actually works. So I think you would be hard pressed to find people who would fill those roles that way. I don't think it's necessary, but I think it is a benefit to have people who've done both sides. I will also say, I think I was a better defense attorney having been a prosecutor. That there are benefits to to having that sort of more well-rounded experience. I just wonder practically whether I'm be able to find enough people who want to do it. Sure.
There's been more recognition in the past maybe decade about the effects of secondary trauma in people involved in the criminal justice system. And I'm wondering if, you mentioned a lot of traumatic events in that you've been having to look in the face day after day. I'm wondering if the institutions that you've been involved in have been like consciously instituting programs or anything that benefit the prosecutors who are dealing with this trauma.
That's a great question. So it was the idea that there's secondary trauma that comes from just being a prosecutor, being exposed to the type of violence and really terrible harm to people on a basically on a day-to-day basis, and whether or not there are programs that are conscious of that. I think there is a greater recognition now that is the case. I also think that for some people, that level of trauma, which I don't know that they would have previously, or even for many people would describe today or recognize today as actually occurring, is part of the reason why some people end up, we were talking about earlier, taking their eye off of the sort of justice focus and moving it more towards achieving a conviction. And I think it's one of those things. Sex crimes prosecutors are particularly, I think, more conscious of the fact that this is something that has an impact on them. And to some degree, yeah, we have those conversations, but I don't know that we've moved the needle all that far in terms of putting programs in place to actually try and deal with the idea that you are impacted as an attorney and as a person by just being exposed to that on a regular basis. But it's something that is obvious. I mean, I don't walk around the city in the same way that I think I would if I were in a different job. Yeah.
E, did you have a question?
I did, and it goes to Bill, Oshana. You talked about some decisions that have this heavy ethical component, and we frame these conversations around prosecutorial ethics. So I'm wondering how you think about how an individual prosecutor, especially in a fairly hierarchical system, military, but a big civilian, big U.S. attorney's office, how do you think about where you go to think through these difficult ethical questions? You may wonder about a spirit officer thinking we're doing something. You have colleagues. How do you balance the sort of your own strong sense of ethics and judgment, whether you're in a supervisory role or a line role, and working through these puzzles? And it's fascinating to me. I wonder about the socialization. When a supervisor gives a broad direction or education or training to is out of line. That's different from an individual case decision. Talked about it within the context of cases. You're a very, very thoughtful prosecutor, and that's why you've been through these fascinating cases. But that balance, how do you think through these tough ethical problems and then decide when to speak up?
Well, I guess I'd say two things.
Just repeat the E's question you would.
Yeah, so the question was, in a hierarchical structure like a military or a large office, how do you think through tough ethical questions? And you go to colleagues, when do you, or how do you make a decision about when you speak up if you think something is incorrect? So I think there's two takeaways. The first is really one that I think is useful for new lawyers and really all lawyers, and that's that you should develop a network of people that you trust that you can reach out to. And so for instance, I'm friends with the chief prosecutor in the Navy, who just left the job of being basically chief of the training program. And he and I call each other on a pretty regular basis just to talk through any issue. It's an evidentiary question, it's a charging decision. And if I had ethical questions, there are a group of lawyers who I've become close with over the course of my career that I would reach out to. I would also reach out to colleagues and talk through issues. I think working collaboratively is important. But to get at the heart of your question, I think that's really a leadership issue. And those who are leading organizations need to create a climate where subordinates are comfortable raising their concerns about issues. And you can absolutely run into places where that is not the case. And there is a very strict adherence to a kind of chain of command philosophy that discourages people from raising their concerns. But I think at the end of the day, every attorney, every person has to come up with their own internal sort of way of deciding when is it too much? When is it the point where consequences be damned, I'm going to say something or I'm going to do something? And that's obviously a very difficult question to answer, but I think it's something that people need to think about, because there are obviously points, right? If my superior tells me, no, you're seeking above guideline sentence, okay, that's lawful, right? But if they tell me that I'm going to do something that is flatly unethical, I think we all just need to be prepared to say, you know, I'm not doing that, and to the extent that you're going to make me, I'm resigning, and or I'm going to speak up, or whatever it is. But that's a tough thing to try and figure out. I think everyone needs to spend time thinking about it.
So let me end by sharing just a couple thoughts, if I may. First, thank you, Major Oshana, for your service to our country. I'm grateful to you for that, for the sacrifices you made in that regard. I'm grateful to you for your continued public service, and I'm grateful to you for being a good example of what it means to be an ethical and conscientious prosecutor. We need examples like you in our country. We need them now more than ever. And if I may, on behalf of the law school, say thank you very much for your time and willingness to come here and visit with all of us today.
Thank you. Yeah, I appreciate that. I guess I would say in closing, I think the role of the prosecutor is maybe the most important role in our system, because we are given an enormous amount of authority and power. And the sports analogy I use is, if you were a coach of an NFL team and before the game, you got to look at the field, and look at both sides and decide whether you're going to play at all. Well, that's a position that carries with it enormous responsibility, but it's also an extraordinarily rewarding profession. And if you do it right, you do it well, it's a great way, I think, to serve the community and also to have a career that I think every one of us would enjoy and would be proud of. And I thank you for the invitation to be here. I thank all of you for listening to me and for hosting me. It's been a lot of fun.